Thank you. Please be seated. This is the time set for oral argument in 1 CACV 17-005. No, it's not. This is the time set for oral argument in 1 CACV 17-0781. Iknadosian et al. Versus Terry Goddard et al. Each side is allotted 20 minutes for oral argument. Appellant, you may reserve a portion of the time in rebuttal, but please keep track of the time on the podium clock if you wish to do that. Out of respect for counsel and the court, I ask that those in attendance please make sure that all the cell phones are off or on vibrate. Counsel, we have read the briefs. We have conferenced this case this morning. We encourage you to keep that in mind when you present your argument today before us. The proceedings are being recorded and will be posted to YouTube. Before you begin your argument, please state your name and the party you represent. With that, Mr. Baker, you may proceed.
Good morning, Your Honor. May it please the court, Thomas Baker, and I represent the three plaintiffs in this action. I'm not going to certainly go through everything in the briefs. I know the court has read them. But I do want to just point out some of the issues that may help put this case in better perspective. And that,
Counsel, before you start, I'd like you to address a threshold issue. Under Arizona law, generally speaking, orders that dismiss without prejudice are not appealable. And absent a couple of exceptions, why do we have jurisdiction, or how do we have jurisdiction over your appeal?
this is the first I've heard of it. It hasn't been raised prior.
Well, you understand we have a duty to look at every case and make sure we have jurisdiction over an appeal.
I do, and I've seen and had cases where I received the minute entry from a court questioning jurisdiction on appeal, but that's usually early on, and then, of course, if necessary, is briefed. So standing here today, having heard this from the...
Well, let me explain one of the exceptions. Let me explore that a little bit further. One of the exceptions is if the claims would be barred, if you would not be able to refile any portion of the claim. Like, you've got there's several claims here, I understand. And if you, because of the statute of limitations, could not refile those claims, or if you would be prohibited even under pursuing the saving statute to allow you to refile such claims. I mean, well, first let's correct something, or let's clarify. You have not sought to invoke the saving statute to refile any of the claims. Is that correct?
Correct.
Okay. That being said, would your claims be barred by the statute of limitations at this point if you were to refile tomorrow a new complaint?
Without the saving statute, yes.
Okay, that's definitive. There's no. I mean, the statute of limitations has long run.
I believe they were all 2-year statute of limitations, but because public employee, they're shortened to 1.
All right, thank you. Unless there's other questions.
And I'll be glad to submit a short supplemental brief on that. I hate to go through the whole process only to have the court find no jurisdiction without an opportunity to at least look into that and respond.
Please proceed.
Having said that,
okay.
The case involves 3 plaintiffs and multiple public employees, which means for every cause of action we have to comply with the state's notice of claim statute and then the abbreviated statute of limitations. In this case, it began as a criminal case. It was an ATF task force involving Phoenix police officers back in a period of time when there was an extreme uptick in violence along the border. And
I'm sorry to short circuit you, Mr. Baker. I just want to know, you were counsel below, correct, at the Superior
Yes.
Court. Why didn't you file a response to the motion to dismiss? You asked for an extension twice. Judge Kiley granted it. He actually granted the day you wanted the extension to be extended to. I think it was August 19th of 2016. Why wasn't your response filed?
as I set forth in the brief, 2 reasons. One, in the motion or in the minute entry from September, it gave a October 7th deadline to submit additional responses.
Well,
to
how does that
requests.
impact your responsibility to file the response to the motion to dismiss?
Because the way it was written, it was read at the time, it was to comply with the October 7th deadline. When we went to oral arguments and this matter came up, and I checked the history, the calendar rather, we did not have that calendar as a responsive date.
But wasn't that date calendaring that, wasn't the court's order calendaring that date set after your motion to dismiss was due? And I guess I'll ask Ms. Iafrate or Mr. Hyde that question as well, but I believe that the date setting that, the order setting that date was set after the August 19th, 2016 responsive date for your response.
The timeline is well set forth, and it's in our opening brief, and I'll be glad.
Well, do I have it right?
I'm not sure. I'll check that. But there was an August minute entry, a September, and an October. And it was the October 7th deadline, and then the dismissal first with prejudice, and then the amended judgment without prejudice, and those
You
were
didn't
in
file a
October.
response on October 7th either.
No, we complied with the discovery as set forth in the September minute entry, I believe it was.
So,
As I reviewed the record, you never filed a response to the motion to dismiss. Is that
Correct.
and yet you did ask for extension of time in which to file
Yes.
A
And then it was
response.
miscalendared
twice?
once.
Just once. You only asked for one extension?
I believe so.
All right.
Go ahead, Counsel. So as this case progressed with the multiple notice of claims and the required multiple amendments to the complaint as the accrual dates came up and up, it took 18 months or so just to get the complaint settled and all defendants on board, because we had an accrual date for the malicious prosecution, an accrual date for forfeiture 1's dismissal, an accrual date for forfeiture 2's dismissal, and the bringing on the additional defendants until all that was done. Along this process and after that process, there were numerous motions to dismiss that were filed by both parties that had to be briefed and argued to the court. At one point, and I think we're 2 years into the case getting to this point, a defendant, an assistant attorney general, was dismissed, resulting in an interim appeal that came up here in this court. The trial court's judgment in that case is Judge Anderson, who had the case for a full 2 years. The court affirmed Judge Anderson's dismissal, went back to Judge Anderson, continued to litigate with Judge Anderson. He held various status conference and hearings, never raised an issue, never was concerned with the progress of the case or whether plaintiffs were failing to prosecute the case. And then in July of 2016, with the judicial rotation, we received a new judge, Judge Kiley, I believe it was, and 3 months later, the case is dismissed as to all plaintiffs, all three of them, all causes of action for failure to prosecute.
The case was originally filed in 2010, correct?
Yes,
And so now we're talking 2016, so it's 6 years
yes.
interim. So you
With-
said it took about 18 months to get the complaint filed and everybody on board. So we're talking
Get
now.
the second amended complaint filed.
So that's, even if that was 2 years from 2010, we're still talking 4 years after you kind of got everything going.
The interim appeal was about 24 months. During that period, neither party pursued, because we wanted to know this was a primary defendant, whether he was going to be in the case or not. And if you look at the appellate index, prior to Judge Kiley taking the case, there's 9 pages of index on appeal showing plaintiffs prosecuting their case, motions, responses, replies, oral arguments, all that. If this was a failure to prosecute, the appellate record would be fairly bare. It's not.
Again, I hate to sound like a broken record here. You didn't respond to the motion to dismiss and I guess set that all out. Would you agree that Rule 7 of the Rules of Civil Procedure allow, I think 7.1b, allow Judge Kiley to do what he did without responding, without a response filed? I believe Rule 7.1 says that you can, it's permissive to dismiss the case.
It's discretionary if there's a basis to do so.
And you did not give him a basis not to do so.
Well, we certainly did in our motion for new trial.
Okay, but I believe the case law that I believe that Appelese cited, the case from 2010 from this court, saying that a failure to file a response alone is enough to dismiss a case under the rule. Do you?
Just for doing it. Same thing for summary judgment. There still has to be a factual or legal basis to do so.
The case law states? To me, it said, the way I read the case was that a failure to file a response is appropriate for dismissal. Just the failure to file a response alone is enough to validate a trial court's decision to dismiss the case. Am I reading? Is my understanding of the case law wrong? I guess is my question.
I believe it's discretionary, but the court still has to find a basis for doing so. And it's not there. Even it's a simple review of the docket would have shown this case was being actively pursued by all three plaintiffs. With that, I'll reserve the rest of the time.
Any other questions? Thank you, counsel.
May it please the court. My name is Robert Hyde. I represent the City of Phoenix, Commander Amy Smith, and retired Detective Arthur Wadowski, both of the Phoenix Police Department. We ask that you affirm the trial court's dismissal of this case and the denial of Mr. Iknadosian's motion for new trial. This case does have a complex procedural history, but the issue for this court is relatively straightforward. These are both discretionary motions, and did this Superior Court abuse its discretion? On the motion to dismiss, Judge Bean correctly pointed out, Rule 7.1 gave Judge Kiley the discretion to grant the motion simply for the failure to respond. As Judge Bean pointed out, Mr. Iknadosian provided no reason for Judge Kiley not to do that. And to the extent any reasons were raised in the motion for a new trial, the trial court did review the record, considered everything in the record, and found that Mr. Iknadosian had a history of failing to comply with court orders, failing to meet his deadlines, and failing to participate in discovery. More specifically, there are at least 7 facts in the record that gave Judge Kiley discretion to to deny the motion for a new trial. Starting with Mr. Iknadosian's failure to respond to the motion to dismiss. Mr. Iknadosian also let the case essentially go dormant for 2 years while the appeal of the Assistant Attorney General went up and down. In fact, no depositions were taken in the entire history of this case, and it is the plaintiff's burden to prosecute his case.
That doesn't strike me as, and maybe you can educate me a little bit, but that doesn't strike me as completely unusual. Isn't it the case that often while appeals are pending, especially appeals on let's say, lead defendants or lead parties to the case, that everything gets kind of put on hold?
Your Honor's correct. However, even assuming that was true, this is a 2-year period out of a 6-year case in the trial court. Assistant Attorney General Mann was added after the fact. He was not a primary defendant. He was merely one of the governmental attorneys who worked on a forfeiture case. He was not the state. He was not the city. He was not the detectives involved in this. And even setting aside the 2 years for that, Mr. Iknadosian took no other depositions in the entire
history of the case?
Correct. Mr. Iknadosian also failed to comply with 2 Superior Court orders requiring him to provide discovery responses. That was in January 2015 and March 2015. Mr. Iknadosian twice failed to provide damage calculations in advance of court-ordered settlement proceedings. That was in February 2016 and May 2016. And finally, Mr. Iknadosian failed to respond to discovery in advance of his own deposition, which was July 2016, forcing the defendants in this case to cancel that deposition. So this is not an isolated incident. It's a history of failing to prosecute this case. The trial court in this case had ample discretion to take the actions it did, and we ask that you affirm. If you have no other questions, I'm happy to cede my time to my co-defendants.
Let me ask you one question, if you could respond to counsel's comments and arguments in his brief regarding the uncertainty or the confusion regarding the dates in the court's order of October versus the court's order of August. Do you acknowledge that there's any validity to that, or is there?
No, Your Honor. The date that Mr. Iknadosian selected for his response to the motion to dismiss was well in advance of the ruling on the motion to compel. Two separate issues. There's about a month in between. And Mr. Baker is incorrect when he said he only asked for one extension. He asked for two extensions to respond to the motion to dismiss. The court gave him the date he selected, which I believe was August 19th. The date of the minute entry granting the city's motion to compel was September 16th. So it was a month after. So how could someone be confused by events that happened a month after the deadline they selected? So there was no confusion there. Are there any other issues? Would you like me to address the jurisdictional issue?
Sure, I'd like you. Sure, yes.
I would agree with Your Honor that ordinarily on granting of a motion to dismiss for failure to prosecute, that would be the dismissal without prejudice, where an appeal would not necessarily flow naturally. However, there are a couple of issues here that I believe provides the court jurisdiction. First, the statute of limitations is long gone without the saving statute. The second issue is Mr. Iknadosian filed a motion for a new trial under Rule 59. After those issues were concluded, the motion for the new trial and the state defendant's attorney's fees, there is a final judgment with Rule 54C language in that. So it would be our position that there is a jurisdiction here.
Would it be your position also that it's too late for him to pursue a motion under the savings statute?
Frankly, Your Honor, I haven't analyzed that issue. I would like to say yes, but I think that would just be a gut reaction. I'm happy to provide any supplemental authority, but plenty of time has passed since the dismissal, and there has been no effort to refile any part of the case.
Let me ask you a question about the attorney's fees award. It seems to me that the basis for the attorney's fees award was just the unreasonable delay argument under 349A3. Given that, did the court below, well, tell me this, does an unreasonable delay argument allow you to get all fees or just the fees occasioned by the unreasonable delay? And if that's the case, did the court properly distinguish between fees generally incurred in the litigation and those attributable solely to unreasonable delay?
That's a fascinating question, Your Honor. However, I think my counsel at table is better equipped since she represents the parties that did get the attorney's fees award.
Since you called it fascinating, I'll let you.
To Your Honor.
Okay. Thank you, counsel. Is he affronting?
Good morning, Your Honors. May it please the Court. My name is Michelle Iafrate. I represent the state of Arizona and Terry Goddard. I'll just piggyback on to my co-counsel regarding the jurisdictional issue. Of course, when we're dealing with the Court of Appeals, jurisdiction is always first. And so there is an exception in this case, although it's appellant's obligation to determine and prove to you that you have jurisdiction, you in fact do. And in fact, this court has found such an exception in McMurray versus Dreamcatcher, something that came out of this court, 220 Arizona 71. It is because the exception is that the statute of limitations is long gone. So
Is the statute of limitations long gone? As I read the savings clause, it says when the case has been dismissed, you have 6 months to file. Now that has run, but subsection B, I think, of that statute says, and that 6 months runs if it's appealed from the time the appeal's entered. So it almost seems like we're in a catch-22, that we could never find one because if it's before us, then it's an appeal and they'd still have 6 months afterwards.
Well, and I think that was some of the confusion in the trial court level, dismissing with prejudice and then without prejudice. I think that added to some of the confusion because there's something in Judge Kiley's minute entry that talks about this isn't a judgment, therefore it doesn't apply. Well, we say this is a judgment and it is appealable, and you should accept jurisdiction and determine it based on the record before you.
But so you at least acknowledge there's some ambiguity in the savings clause as whether it would.
I would agree. However, I would also.
I'm sure if this goes back, you'll be arguing that it is time barred net.
Of course.
Right now, you're.
Of course. So, Your Honor, I wanted to address your attorney's fees issue. Do you want me to jump to that?
Please.
Okay.
Since it was fascinating.
It was fascinating, especially because he got to sit down and I got to stand up. So, Judge, if you look at the 2-minute entries that Judge Kiley issued, he did an amazing job going back through the record in both of those minute entries. And in fact, in the minute entry that deals with the attorney's fees, it's dated October 2nd. He asked for additional briefing regarding the very issue that you asked about, and that was not all delay equals unreasonable delay. So you don't get all your attorney's fees just because you won. So pursuant to the statute, we went back through and we addressed the different areas in which we deemed there was an unreasonable delay, not just a delay. There were 6 different issues. Judge Kiley addressed all 6 of those issues and denied some that he believed you were going to have to do that anyway. That wasn't an unreasonable delay. But as to the other 5 remaining issues in that October minute entry, he went line by line through whether this was an unreasonable delay or something that was just normally part of litigation.
Let me focus a little more, and this may be a rabbit hole that isn't fruitful, but humor me.
Okay.
One of the things that he did award fees for was as he explained it, failure to prosecute led you guys to file the motion to dismiss. So you guys got the time for filing your motion to dismiss for failure to prosecute. I buy that argument insofar as it led you to file a motion to dismiss. But since it was successful, it seems like it saved you time that you would have, a lot of time that if it had been unsuccessful. So it's almost kind of, and I'm not entirely sure where I'm going with this, except that because you were able to basically short circuit and cut off the litigation, it seems like it saved you a lot of time down the road that wouldn't have been compensable. But since you were successful, it was a savings as opposed to a cost. Are you following my logic at all?
I understand what you're saying, but I disagree with that analysis that you just said, and if I could explain why. So we received fees for preparing the response and the oral argument for the motion for new trial.
Okay.
That was the first one. And we received those because we were successful in the motion to dismiss for failure to prosecute.
Okay.
So it wasn't the preparation of the motion to dismiss for failure to prosecute that we got the fees. It was the fees for the motion for new trial and the preparation for and the attendance of the oral argument for the motion for new trial.
So you didn't get fees for prepare the motion to dismiss?
Correct.
Okay. That alleviates my concern, and I maybe misunderstood the record. Thank you.
But let me follow up on that. So if one of the court's reasoning, the court explained that delay was caused by failure to prosecute. But is that sort of an all-encompassing terminology that the court used? I mean, that there were many instances of failure to prosecute it seems to me like there'd be, because the court also noted failure to comply with discovery, failure to provide disclosures of damages, failure to offer specific responses or objections to requests for expert disclosure, et cetera, et cetera. Do all of those fall under the umbrella of failure to prosecute, in a sense?
They could, and they did here. So in this situation, what Judge Kiley determined was, based on just Rule 41, failure to prosecute, the appellant didn't respond. So pursuant to Rule 7.1, that in and of itself should grant the motion to dismiss for failure to prosecute. But in this case, there were even more situations that would bootstrap onto this failure to prosecute, which were the ones that you pointed out, the failure to remedy the deficiency in the 2 motions to compel that we filed and were granted, the failure to supplement the response as the court ordered, the failure to meet and confer regarding deficiencies, the failure to provide damage calculations, the state's inability to effectively depose plaintiff because we never got the discovery that we requested. So therefore, plaintiff's deposition had to be canceled. The state had to extend the deadline for the expert disclosure because we didn't have the discovery that we needed. Therefore, that had to be pushed off. So these individual situations for failure to prosecute was causing all the deadlines to be backed up. And the judge had the ability to dismiss this case to control his own calendar. There were many, many opportunities to force appellant's hand to provide the necessary information. Judge Kiley didn't just pull the trigger on the first situation. What happened was there was a culmination of events that led to the state filing the motion to dismiss for failure to prosecute, and the judge in his minute entry regarding the motion for new trial went through all of the different instances in that minute entry regarding the failings of appellant and why he, in the end, granted the motion to dismiss for failure to prosecute.
Ms. Iafrate asked Mr. Baker if a failure to respond to a substantive motion to dismiss alone under a case law, under rule, is sufficient to allow Judge Kiley to grant that motion. And I don't have the case in front of me. I believe you or your co-counsel cited it in their briefs. But I know it was a case out of this court in 2010. Am I correct in remembering that case, that just if the failure to file a response in and of itself is sufficient to allow a trial court to grant a motion to dismiss?
Yes, Your Honor. First of all, Rule 7.1, which you cited previously to appellant, but also Van Orem Strategic Development versus 7th and Roosevelt. That's the case out of yes, that's the case out of this court that says that it is within the court's discretion. Period.
Is there a conflict between that case and I wish I could remember the exact sites or names? There's a thread of cases out of our court dealing with summary judgment motions which say, not so much. You can't just, failure to respond is not sufficient basis to grant a motion under that case, despite Rule 7. So how do we reconcile those two cases, or 2 lines of case law?
I don't necessarily think that they're divergent paths. Surely the trial court and this court wants cases to be decided on the substance of the case, not some mere technicality. I think that that's the line of cases that you're talking about. In this case, it goes beyond a mere technicality. In this case, plaintiff himself chose August 12th and did not file a response. He chose August 19th and didn't file a response. It went another month and a half before the judge finally said, okay, no response is going to be filed here, motion dismiss. So this confusion or miscalendering, put that aside. Here, it was essentially 3 times plaintiff failed to respond to a motion to dismiss. Those cases, I understand we all want the substance, but this is a unique situation in which plaintiff controlled the trajectory of this case. He alone had the ability to continue this case or not. It was his actions that led to the dismissal of this case. It wasn't a mere technicality that the trial court didn't want to deal with the substance of this case. I think that both of the minute entries written by Judge Kiley indicate that he went through the entire record to show that in this case, this is not just a mere decision because someone didn't respond. In this case, this was a belabored situation where plaintiff failed continuously to prosecute his case. And it is correct that not one deposition was ever taken in this case.
Would you argue that in addition to denying it under Rule 7 for failure to respond, did he sufficiently address the merits in his order that we could bypass that issue altogether?
Well, when I was talking about the merits, Your Honor, I was talking more about the civil case itself, that a trial judge would like to resolve the civil case, the counts that were charged within the complaint.
No, I'm talking about the merits of the failure to prosecute.
Oh, definitely. Definitely, Your Honor. As I was explaining to Judge Brown earlier, there were two separate reasons for the motion to dismiss for failure to prosecute to be successful. One was the failure to respond, and the other was the litany of failures by plaintiff to respond, to fulfill the court's orders, even after repeatedly requesting, and the settlement judge asking specifically for documents and calculations that were never provided, which led to the vacation of the settlement conference. So yes, I do believe that Judge Kiley didn't just say 7.1, therefore I have the discretion to do so. He listed all of the failures by plaintiff that led to the motion to dismiss for failure to prosecute. Then Judge Kiley further listed all of the reasons for the failure of the motion for new trial, and then within the attorney's fees, again listed the reasons why some of the attorney's fees were granted because of plaintiff's own actions.
Thank you.
It appears that I'm out of time, so I will sit down.
Thank you, counsel.
Thank you, Your Honor. Let me touch on a few points. The issues of depositions have come up. Prior to getting the second amended complaint filed and the case proceeding, we had trial testimony transcripts from Mr. Iknadosian's criminal trial. We had extensive search warrant affidavits and seizure warrant affidavits signed by one of the primary defendants in this case, Amy Smith, who was a co-agent in the case. So we had those sworn statements. We had the all the discovery provided by the state through the criminal case and through the forfeiture proceedings. So we had already a lot of sworn testimony in our possession. They had in their possession.
That explains why you hadn't been out seeking discovery, but what about all the times when plaintiffs didn't respond to their discovery obligations?
Well, let's go through
back
that.
to the state.
Because Judge Anderson had the case for 2 full years. And although the state raised these issues, Judge Anderson, you can see through his minute entries, addressed them all. And one of his final minute entries, he stated, and he bolded right in his minute entry, these issues are resolved. And they were resolved one way by, I told Judge Anderson, let the defendant's attorney come to my office. I have 12 banker boxes. They can go through it page by page and see what they want. Judge Anderson said, that's a good idea. Let's have the defendant's counsel do that. So they came to my office and they went through 12 boxes. And lo and behold, almost every document in those boxes had an AG's bait stamp on it. Is when they did the seizure warrants, they did the search warrants, they seized everything. Business records, bank records, rent ledgers, personal bank and financial information. And they had the document in their possession for over 2 years. The AG was the one who prosecuted the criminal case, not the county attorney's office. And finally, after forfeiture 2, we got all this stuff back. Their bait stamps are on, so they scanned it and bait stamped it. And they had all that information in their office for at least 2 years before we got it back. And they said, give it to us back again. You're withholding disclosures. And so after that meeting in my office, they're going through the bank boxes. I think they came up with maybe 25, 50 pages, miscellaneous stuff they wanted copied, and we copied and gave it to them. Judge Anderson says, that's fine. At no point did they raise failure to prosecute. At no point did Judge Anderson say, look, you need to move this along.
What were the documents that caused them, or the failures, the discovery failures that caused them to cancel the deposition of your client?
To this date, I'm uncertain, and let me tell the court why. When we had the first settlement conference, Judge Herf, in his emails, as attached as exhibit, stated that there are two issues. One, the state has not provided discovery. We served requests for production on defendant Goddard, and it took 9 months to get the responses. We didn't have them at the time of the first settlement conference. And then they claimed they didn't have damage calculations for one of the plaintiff, the business, on one of its claims, and that was the damage to the weapons when they were all seized by the defendants. But in their settlement conference memorandum, they had some certain amount of $203,000 that they calculated to be our damages. And the way they were able to calculate that was because we had given them all the raw data, all the invoices for the purchase, the auction sales, hundreds and hundreds of photographs showing the damaged inventory. And it's based upon all of that they came up with that number. Yet they turn around and argue we didn't have the damage calculations for that one plaintiff on that one claim when they had some certain amount in their settlement statement. So when you say what evidence do they have, I'm not sure. They've never specified. In fact, I asked Judge Kiley, hold an evidentiary hearing, let him prove up what specific items as to which specific plaintiff, as to which cause of action they don't have. Judge Kiley would not grant an evidentiary hearing. Because remember, there's 3 plaintiffs. They have separate claims. And damage calculation that they seem to be referring to is referring to X caliber guns, not Mr. Iknadosian, and not the property. And as to the claim for wrongful seizure and more specifically damage to those items, for which we gave them everything we had, and they came up with their own dollar amount. As to the attorney's fees award for unreasonable delay, again, they argue that they hadn't been produced all the discovery, but they never articulated what discovery to which plaintiff for which counts. So certainly lesser sanctions could have been imposed, if Judge Kiley believed that to be true, on a particular plaintiff for a particular cause of action, or a motion in limine or a limitation that evidence that has been provided, which they use in their settlement conference memorandum, is admissible, but additional information would not be. That would not affect the causes of action for the other 2 plaintiffs, and would only affect that 3rd plaintiff, the Excalibur guns, based upon its claim for damages for the seizure and the damages to the firearms, which we had pictures of, hundreds of photographs. We had to give them to them on a thumb drive. There are so many photographs. And it's important to also keep in mind that the time Judge Kiley took the case in July, Judge Anderson had issued a scheduling order by stipulation of the parties, moving the discovery, the expert, and the trial date into, I think the trial date was set for January of 2017. So Judge Kiley dismissed the case, all plaintiffs, all counts, for failure to prosecute while there was a scheduling order in effect setting forth these deadlines for disclosures. And that didn't seem to be important to Judge Kiley, that we were working off a stipulated scheduling order at the time of the dismissal. The 9-month delay in defending Goddard producing the emails that we had requested caused the second settlement conference to be continued. They had our damage calculations, although they say they don't, but they came up with 203,000 some certain based upon what we gave them. But they had not produced after repeated requests and assurances would have them, the emails, the request for production from the state. And Judge Kiley didn't address that. Certainly the defendants don't want to address that. That's a 9-month period that we can't get discovery for emails on a defendant. And to date, they have never responded or explained how that 9-month delay didn't affect the prosecution of the case. We can't move forward against that defendant, certainly can't take his deposition without having the emails, and we couldn't get them for 9 months. So with that, unless there are further questions.
Thank you, counsel.
Thank you, Judge.
I'd like to thank you both for your briefs and presentation here today. We will take the matter under advisement and issue a written ruling in due course. At this time, the court stands adjourned. Thank you.